Hi, good morning everyone. I think we should start. Hi. So, dear colleagues, welcome to this session on the future of the trademark profession, the depressing future or the exciting future, the future for some of us and not for others, we'll see. So, my name is Benjamin Fontaine. I will be moderating this session. I am the old guy here, I am the past, that's why I have a tie, and my colleagues don't have a tie, that's part of the future. Before we start with the subject, I'd like to tell you a little story. I am a member of one of the committees of ECTA, and by the way, you should, if you're excited and if you want to participate in one of our committees, they are the core, the essence of ECTA, and please apply if you want to discover wonderful stuff about GIs, legal issues, harmonization, etc. So that's the advertising I was supposed to do. So I am part of one committee which is called the EU-IPO Link Committee, and we are the interface between what ECTA is doing overall and the EU-IPO. Okay? And this committee has the privilege of having a meeting every year with the management of the EU-IPO in Alicante. So I attended, and we had, and I must say not everyone has these opportunities, so we are glad with this. We attended the meeting last time, it was in February this year, and we had a very interesting discussion with Antonio Campinos, the executive director. He was talking about the future, and he was talking about all the efforts the EU-IPO is doing in terms of artificial intelligence, big data, etc. What does it mean in concrete terms? I'd like to tell you, it's very interesting. If you look at opposition decisions, you all do oppositions before the EU-IPO, you're quite familiar with this. It's very interesting because today the examiners have tools that they have to use and they have to follow the decision-taking process of the EU-IPO. So whenever they have to compare one product and another, they use a database which is called a similarity tool, and the database says yes or no, it's similar, to which extent, okay? And they have to do that. They don't care very much about what you are writing in your submissions to argue whether these goods are similar or not. And that's step one, and that is what we have today. The problem is that Antonio Campinos explains that tomorrow, what you will have is an automatic pair of products and services made by the IT system of the office. So the office will be able to compare trademark A and B to see what products and services you have in each trademark, to compare them, and to say you have to compare sockets with hats, and shoes with leather cream, etc. And they will give you these automatic pairs, and they will give you the result of the comparison. Okay? Step two. The next step will be, well, actually, if you can find the pairs automatically and the result of the comparison, let's write the decision automatically in the decisions. And that will come very fast, dear colleagues. Very soon, the part of comparison of goods and services will extract automatically in a few seconds from the IT system of the EU-IPO. Okay? That's for after tomorrow. And the day after, they will do the same with the signs. They will be able to compare the signs because there are so many decisions and so many possibilities to do some comparisons technically that we will end up with a decision fully drafted automatically. Okay? The examiners will only review and correct if they feel there is a need to correct the decision. So we had that look from Antonio Campinos on the other side of the table. And what are you guys going to become? And actually I said, okay, well, we will adapt or die. Okay? So I think that this should be the title of this session. We must adapt or die, because if not, we will disappear. So to have this entertaining discussion today, we have three wonderful colleagues. who have thought a lot about this issue and who will give you their thoughts, okay? The format of the session will be a bit unusual. There will be no presentation. You will have to listen to us and look at us. And you are invited to disagree, to shout, to raise your own questions, and to intervene whenever you want, okay? This is like an intimate chat, or the room is quite big, okay? By the way, it's interesting because maybe some of you have read, there are many books and articles and videos on the future of the lawyers. But in our profession, in the trademark field, the technology will have, I think, a higher influence because there are so many decisions and there are so many things that can be standardized in our practice from a legal perspective. This is even a higher threat and a higher need to adapt our working methods and our offer to our clients, okay? For example, I don't have it here, yes. You had in your folders of the conference the information from .IP that you all use probably. .IP has nearly 2 million cases in this database, and it's adding 50,000 cases per month. So this huge data, of course, plays a fundamental role and kills what we can bring or what we brought before. So, our speakers, ladies first, we have Monique Ranman from Nova Graph. She will be one of the speakers. We have Karel Sindelka, who comes from the Czech Republic, and the new second vice president of ECTA, so a very important person, Mladen Vukmir, who has also given great thought on this subject. Okay, so dear colleagues, I'd like you to present yourselves. Monique, what do you do for a living today?
Well, today I am an IP attorney at Nova Graph, prosecution mostly.
And where were you 10 years ago?
10 years ago I was also at Nova Graph already, but things are quite different back then. In hindsight, maybe a little more laid back even. We had paper files. I can't even remember, but we did. We wrote letters.
Yes.
Clients were much more patient, I think, because they were used to longer responses due to the mail and things went slower. We had no back office like we have now. So all in all, I guess we were much less efficient.
Okay. And so, where will you be within 10 years, exactly?
I think nowadays IP is has still a very traditional business model, and it's much under pressure because of the increased development of technology. And I think that technology such as blockchain and artificial intelligence will probably cut out a great part of the so-called middleman in the profession for many IP services that we do nowadays. So that could mean a decrease in the number of firms, and then the question is, of course, who will survive in this scene.
Yes.
Nowadays we do, for example, a lot of work that I would like to call rework. Things like office actions on classification, specification of goods, or office actions on what legal form the company is when that's not clear. All work that will probably, or most probably not be necessary when we adopt those technologies. So a lot of those work, the managing of that administration, and the digitization of other administrations will cut out the work, so less people are necessary. On the other hand, I think that will make that we will have more time on our hands to do what we're good at, so we can specialize in high-end quality advice, and maybe even give holistic strategic advice to our clients more than we have time for now. So I guess we have to take a new role in the business. Apart from the work that is done, We have to take a new role, like is being done in other industries where, and other professions where technology is much further ahead. For example, in medicine, where doctors still have a very important role, even though robots can perform operations on human bodies. But that doesn't mean that the doctor is less important. He's still very important. And also for a much longer time, pilots have been flying with automated pilots on the airplanes, but still have an important role in the airplane. I don't know if that will still be the case in the future.
Let's not talk about airplanes, because I think it's safer when pilots don't intervene. That's my experience. Thank you. Karel, can you please tell us what you do for a living today?
I'm an IP attorney based in Prague, and I'm a fully qualified lawyer, which makes it possible for me in the future if I see that there is no work anymore for IP lawyers in the Czech Republic, I can switch to criminal law if I want. So, because I think
that will always be needed.
I think there will be the automation and technology in criminal cases will still be lots of face-to-face consultations and litigations. So, but this morning I have checked my calendar, what I've done actually 10 years ago, and I've noticed that I have not been an ACTA member. Apparently, I suppose I was sitting in my office in my old firm in Prague, and wearing a suit and a tie, because we used to have we were allowed to wear jeans only on the so-called casual Friday. I don't know if it still exists.
Friday. Today's Friday.
So these days are gone. No, seriously. I was thinking and looking backwards, and I've realized that I didn't have a Facebook profile 10 years ago, didn't have a LinkedIn profile, didn't use WhatsApp, had a small Nokia mobile phone with no touch screen. Although we already used email for communicating with clients and counterparts, we still had a fax machine in our office, and we occasionally used it. And obviously what has changed a lot is that we filed all submissions on paper and sent the assistant to file them by the close within the opening hours of the office. So this has changed a lot, because nowadays 99% of what we do is filed electronically.
So you were like I am today, 10 years ago. Okay. Where will you be within 10 years, Karel?
I hope this time of the year I will be attending 47th annual ACTA conference.
Bravo.
We have 37, so, and while occasionally checking my lawyer bot, processing all the IP work in my home office.
Okay, thank you. So your turn, Mladen. What do you do in your daily life today?
I'm afraid I don't know really, because I have been elected second vice president only a couple of days ago. So it will bring a big change, and certainly I won't work for a living, but for benefit of our profession and the IP world. 10 years ago, I worked in a country that came out of the war and had a tremendous opportunity for growth, and equally chaotic, you know, which is normally associated with big opportunities. So the firm which we have founded actually at the time of independence, I came back from the US in '92, and that's where we founded the firm. It was still growing. This is very different today. We have a firm that is well functioning. And the one thing that I noted here is that there was a little bit of advantage setting up of a new firm. For instance, we always presumed that filing work will be a commodity work. So we didn't have to shift, you know, employees from a larger filing department somewhere else, or lay them off or something. it was always built on the premise, you know, we have actually, I realize now, have seen the path it will be taking. Although I have to say, you know, I always loved technology. That's why I was in Silicon Valley, that brought me there, and I was always looking what's the next thing coming. I could have not imagined this level of influence of technology driving our profession. This is only picking speed now, so I guess that in my spare time in the future I will have to deal even more with the decisions related to technology impact on profession.
And in 10 years, what does it mean practically? What will you be doing in 10 years from now?
Well, I am in the age of where I can say I will be retired. I'm joking because I'm not kind of a person that thinks much about retirement. I will probably be doing something with the climate change. I have some projects where I participate, you know, that might be you know, one of the things that I will be doing.
Okay, thank you guys. So, as I said, there is no presentation, no specific line to follow today, but we have at least structured this panel in 3 parts. We will first analyze what is happening around us. Okay, not us, the IP lawyers or the IP firms or the in-house lawyers, but what happens around us, service providers, IP offices, etc. What they will offer within 10 years. That will be our first element. Then we will analyze what we will become, what we have to offer in the future, how we organize ourselves, and we will finish with a 3rd part about billing, about cost, about how we make money of what will be left to us or not. Okay, so let's start then with the changes in the environment, and I would ask Carol to start. Please, because you have a number of interesting examples to provide to illustrate what is going to happen or what might happen in the future. Carol, please.
Thank you, Benjamin. Maybe an initial note. I don't know if many of you know that the word, we are going to talk a lot about robots and bots. And if you know that the word robot has Czech roots, actually it was first used by a Czech writer, Karel Čapek, in 1920 in his play R.U.R. To denote a fictional humanoid. And also the word robot, it's from an archaic Czech word robota, which means forced labor. So it has also interesting connotations, future. And concerning the contest, what I found that there were two contests between the human lawyers and robots and artificial intelligence. The first was a case from US where they picked 20 highly experienced US attorneys and pitted them against artificial intelligence called law geeks. And the task was the contract review. They provided them with 5 non-disclosure agreements of different length, from 2 to 5 pages. And the task was to spot certain or to identify and highlight certain topics such as non-restriction, liability, not only the definitions but the possible exemptions from the definitions and so on. And then they measured the results. They measured 2 things. They measured accuracy and they measured the speed. And as far as the accuracy, unfortunately, as you can imagine, the human lawyers lost on average. They lost their accuracy in reviewing the non-disclosure contracts was about, I want to be precise, so let me check the figure, 85%, and the AI or the lawyer bot achieved 94% accuracy. The least performing lawyer achieved only 67 accuracy.
He was not a member of ECTA.
Yeah. I don't know. And what was even more striking was obviously the speed. On average, it took to lawyers, to humans, 92 minutes to review these 5 non-disclosure agreements. The slowest one, it took him almost 2 hours. The fastest lawyer, only 5:51 minutes. And the same task was performed by this Logix AI in 26 seconds. So imagine that, and imagine impact on billable hour. You know, normally you would bill an hour and a half, and now 20 seconds, and how to bill it. Okay. So that's a first case. And the second, those that are from UK maybe know about it. It happened in fall 2017, and it was the contest in predicting the outcomes of actually PPI missold claims. PPI is a private payment insurance, and this were just these cases where they are missold by the banks are decided by Financial Ombudsman Service in UK. So they invited London commercial lawyers to participate in this contest, and there were about 100 lawyers that signed up for this project, and they were provided with real cases. The outcome of these cases was known. They obviously blackened the identification, but they gave them all the facts. And just the task was simple, to either say whether the case was upheld or rejected. And again, the same task was given to a AI which was called Case Cruncher Alpha. And again, they measured the accuracy. And in predicting the outcome, obviously the Case Cruncher was more successful, reaching more than 80% of correct predictions, while the human lawyers were around 62-64%. So these 2 examples show that there are certain activities where we simply will be outperformed by AI in the future, and that we will have to focus on other activities where we'll still have the advantage as humans.
Thank you, Carol. It's easy to see how these artificial intelligence can play a role in our works. Imagine that in 10 years, when CompuMark sends you a watch notice, it will not only give you a trademark published in some gazette, it will also give you the percentage of success in an opposition based on the area trademark of the client and for which goods and which services. Thank you. Okay, so that's one very big, important change. Then another issue we have to deal with for the future is the constant increase of services offered by the IP offices, the administrations, which to some extent become also competitors, or at least withdraw part of our tasks. I'd like Mladen to give us his thoughts about this, please.
Thank you. Yes, this is certainly an issue of concern for all professionals, for the professional associations, and a lot of time is spent on these issues and trying. Some people propose tougher regulations and increasing the monopoly, essentially, of our profession over providing this type of services. I am suspicious that this is a fruitful spending of energy. I don't see really these clear borders holding. And it won't be only patent offices who actually started competing more than a decade ago, probably. And I first actually have realized how far this has gone at the Danish patent office, which I visited at one point. So I said, you know, all these three things that you told me that you have introduced over the last year are actually something that either competes with service providers or goes beyond that, and you know, I don't know, criteria for building IP strategy for a small and medium business. You know, they had a software tool for doing that. So I personally have accepted this as a matter of fact, you know, and I don't try personally to raise obstacles to this. There will be many other competitors. There will be software companies. There will be open source providers that will take benefit of the software solutions and will actually provide perfectly acceptable services. You know, one reason why I think that the resistance is futile in this is that actually our consumers are happy when they have other providers. There is something in the way a legal world functions that seems to turn off a big part of the businesses and the big part of societies, modern societies for that matter. So all of you, I'm sure, know how hard it is to go out to the street and sell services to the people who actually are looking to avoid them. Many small businesses don't think they need this type of service, especially though they don't think they need to pay for it. So I have, you know, obviously I think what we need to do, and this is probably part of another question, but I need that we need to face this fact that it's not given that it's only us who can provide intellectual property services.
Thank you, Mladen. Monique, another factor of change around us is the service providers, actually, as we said before, Darts, CompuMark, Core Search, and so forth. I think we were very happy to have them. We will still be happy to have them in 10 years?
I think so, yes. I think that the goal of service providers such as Darts IP and CompuMark, Clarivate, that the goal of their artificial intelligence is to, at least for now, to complement IP attorneys and lawyers, and not so far to replace them. As you said, they already give us many advantages that are very important on searches and watching. It gives us speed and efficiency in providing advice to our clients. They can give us quick and accurate decisions, so there are many advantages to complement us. I don't think that we will be obsolete by those things. There's still added value for us humans to those artificial intelligence outcome of those products. There still will be needed holistic strategic advice, and especially in relation to portfolios that the service providers don't have the information on. And we have to check if the outcome of such product is logical, and if there's a novel situation, then only humans can tackle it, because artificial intelligence is, of course, based on vast amounts of data, but not on data that doesn't exist yet. So I don't think it is a threat. I think it will complement, at least for now. Maybe in future it will be different.
Thank you, Monique. Now, Monique, you again, sorry. I'd like you to shape for us how will be the trademark law in 10, 15, 20 years from now, and because this could also have some influence in what we will have to do. What will be the trademark law in 10 years, 15 years?
I think in general that IP will still become more important, and the world will be getting smaller, even more. The Madrid system will probably be bigger and possibly even worldwide when countries adapt. Maybe at this point some countries are not so adaptable to systems like that. for example, countries that have very large backlogs in their administration. But on the other hand, countries are catching up, such as Brazil, who took a very long time until recently, and now they are able to provide very quickly the procedure between application and registration of a trademark, so they are more adaptable. And I think countries that may be underdeveloped right now, such as African countries, they will probably skip some technological steps in the future. That's because of the scalability of technology. They will catch up. You can compare that to the telephone branch. There are countries that skipped the landline telephone system and went straight to mobile phones. So that's the scalability of technology that will make that countries will be more adaptable to one system. As said, examiners will work with stricter protocols and will probably be more objective in their decision making due to the things that you said before, Benjamin, the tools that they have, but also stricter protocols to follow. For example, the ICE project that we have discussed in the EU IPO Link Committee, where examiners are where there are only 12 examiners who have to examine all application on absolute grounds. So there are possibilities toward a worldwide register and law in that matter, not necessarily by WIPO, but at least made possible by technologies such as blockchain, and things will be might be all harmonized, I guess.
Okay, so blockchain was mentioned at 12:10, so we managed not to mention blockchain for 40 minutes. Mladen, you wanted to add something?
Yeah, I wanted to grab the word worldwide that Monica showed, because I think it gives part of the answer from my past discourse. And this is part of the answer why people don't want to use the IP systems as we sell them. And it's not our fault. Part of it is that it is not worldwide. We still have territoriality enshrined in the Paris and Bern Conventions. I would submit that this is at odds with modern economy. You know, the force that feeds our little mouths and our societies, which is the economy, really suffers from territoriality. So, and we are not doing anything to look at any possible alternatives, although we were quite good with coming up with patches. The Madrid Agreement is an excellent patch, and I mean, we should allow ourselves to be proud of what we have achieved with the European system, because this is still the only supranational IP protection system in the world. So this is a big civilizational achievement. I don't think that we congratulate enough ourselves on achieving this, but we need to go further.
Good. Thank you. Anyone in the audience has something to say, or you all agree? If you want to say something, just... Yes. Christian, at the back.
This is Christian from Germany. Just a remark as to the services provided by the trademark offices. Of course, it's very, very appreciated that they have nice search tools, but of course, somehow they enter into competition with the private providers like Sages and Core Search and so on. And one may ask the question, I mean, they do that with public money. They do it with the money of us, of the users, and whether by that way we just fund, whether it is correct that we fund such services, which usually should be private services, not public services for everyone. Just a thing to think about.
Dear colleagues.
If I may say, I think it's always, there is a demand for such services from the users. So they say that they want these services to be available for free. So they are just meeting the demands. They don't want to pay for it. That's and that's what's happening.
Yeah, I think it's fair that they do what they do in general. They make money out of the filings and they make normally quite good use of it, at least in the EU IP office. In this respect, I don't think we can criticize too much. What we have also as a threat was an external layer of complication for the future, but even today around us, is the issue of new competitors and deregulation of the profession. If you look at the daily reports of WIPO, for example, on domain name decisions, on UDRP, more and more the claimants are represented not by IP firms or by lawyers, but by other kinds of providers. And this will grow in other areas for sure with the assistance of deregulation. Karel, can you give us some thoughts about this issue, please?
Thank you, Benjamin. As we all know, providing legal advice and services is a reserved business. But I don't know if all of you know that in, I think, September of last year, there was a paper, recommendations of the European Commission that circulated among the council members. And I would like to be precise, I would like to quote what were the recommendations of the European Commission in relation to legal profession and further liberalization. And ECTA made a fantastic, a very good position paper to that as an answer. And just to be precise, Commission proposed that the legal regulations should clarify the scope of the reserves so as to facilitate the provision of legal consultancy services by lawyers or other service providers, particularly online. So we will more and more face the pressure to liberalize our profession. That's obvious. ECTA obviously in the position paper, so for those who didn't read that, obviously refuse that. Because we believe, as if you want to do a brain surgery, you don't want a Joe do it. So also the legal services should be provided by professionals that have the necessary qualifications. And anyway, but I think the legal profession as such, and whatever lawyers, trademark attorneys, and patent attorneys should enable at least some liberalization. We should not try to protect our business so heavily. And I'll give you examples where I really believe it's desirable that some deregulation happens. I was surprised, I searched and I was surprised to notice that in many jurisdictions around the world, not even multidisciplinary partnerships are possible. For instance, in the Czech Republic, a lawyer's firm can only have lawyers as partners, no patent attorneys, no tax consultants, and so on. And there is a lot of such jurisdiction where this is not possible. Also, it's not possible, with exception of England and Wales, to invest for non-legal provider entities to invest into a law firm to share the profit of the law firm. And obviously, I believe this is a weakness because we are losing the market to other online providers and others because they are by far more technology advanced. And our possibility, if we have a chance to involve other like IT people into our firms, this could help and this could increase our competitiveness. And as far as I've made the search, only UK basically allows under supervision of bars of the solicitors authority in England and Wales and few jurisdictions around the world. Otherwise, it's not possible for non-lawyers to become partners of law firms. And obviously, I still believe that such step would be welcome, because otherwise we really will face the competition which will anyway come. You can see it with Uber. They come, they invite the cities, they compete. There are lots of injunctions in Germany, in Czech Republic as well. There was injunction, but anyway, they are taking the market, and people want that service. So I'm afraid to avoid that something is happening, we should be more open to liberalization as a profession as well.
Thank you, Kyle. Another layer of complexity we have for the future are the clients. We love our clients. Will they love us in 10 years? What will they need? What will they want? More for less? What are the future client needs, Monique, in your view?
I think that we already see an evolution of client needs. They need quick results. They need solutions to their problems, practical commercial guidance, and someone to think with them instead of long, in-depth legal advice for which we bill hourly rates. There's a need for cutting costs and efficiency, and it's a faster moving world, so there's a need for quick and accurate answers. So there's a client calling right now. And also for clients there is more information available, at least a lot more than 10 years ago, and probably much more 10 years ahead. So there's more transparency to what we do. They can take it themselves, and also there's more transparency on the costs of our services. So that's also something to remind. So all in all, I think that clients need less expensive but high quality added value from us, also in the future.
Okay, thank you. Any other thoughts, colleagues, on this issue? Mladen?
If I may, I don't want to oversimplify or sound foolish, but we need all to learn that life should be fun, and the businesses as well. So one good product to sell, if you enjoy what you do, as I do, is to sell fun in helping them, So I'm very much for affirming values that are not part of the set of the 20th century professional. I see big changes in the future in that respect, and I will elaborate later on that.
Okay, and from the room? Yes? I give you my micro.
Fabrizio De Benedetti from Italy. Just a comment about what you said up to now. I, of course, agree with the presentation of the future that you have made. And a comment about that, on my view, is that a side effect will be that the quality of the people doing our work and also other professions will decrease. Because if you have additional increased automatic means, software, computers, doing certain kind of work and giving certain kind of results, even decisions in connection with what you mentioned about the decision which are taken now by the examiner in the EU IPO for similarity goods and services. If that will be more or less automatic, you would not need to have specialized people or expert people doing the work. And that would be the same on the other side. I mean, also for practitioners, you would not need such great quality, particularly when the same means will be available also to consumers and to the professionals themselves. And the great risk in this is that the quality of assistance made by us or the quality of the decisions taken by the office will decrease because it will not take into consideration some specificities of each case, and particularly for complex cases, because the tendency will be to use the automatic means in order to guide the final decision. So this sort of justice automized, I think is a big risk for everybody. And a final note, it's true that the world is becoming smaller and that people, consumers, would like to have a means and also protections worldwide, possibly without pain. But politics, particularly in these days, will show also some risk in that respect, because there are also some opposite trends in which the world is dividing instead of unifying. Thank you.
Thank you. I'll come back to you afterwards, Philippe. Any comments on this? Yes?
Gladly, and thank you very much for this important contribution and observation. I should say also, I have double citizenship. I'm also an Italian, so I recognize a lot of echoes from the professional attitude in the country, which is very defensive. There is concern. Italy, unfortunately, is not driving reforms, and there are always good reasons. We live in such complex societies nowadays that almost everything that we observe and what we comment is correct. So I agree with the points, even those that I don't personally share. However, I wanted specifically to address, this what you said about the quality of the services. Do we have nowadays any chance to complain about the quality of the cash machine, of the bancomat, or whatever, in our countries is the word for automated cash tellers, as they were called 20 years ago? No one complains about the services of automated cash tellers because they just work as they're supposed to do. With the level of technology that was available 20 years ago, we eliminated a professional that was called bank clerk, with whom we might have shared, personal relation and enjoyed, even knowing private details from private life. And now we have a PIN code, and then we get the service that we want. There's a whole set of laws in every cash machine on every corner of our cities, that work completely automatized, observing the privacy concern, the monetary, financial regulations, and so on and so forth. This is, I think, a good example of how technology comes into our life, and we then just accept it and improve it and so on.
Maybe. Hi, I'm Philip from NER, Alicante, and I just wanted to put another idea in the room. As artificial intelligence makes it possible to see very effectively the use of a brand on the market, it might even be possible in the future just to not rely on registered rights and abolish trademark registries, because you can easily see what is on the market if you see a product is launched. And many IP disputes nowadays are like paper conflicts if you do clearance searches and all this, and this could be a possible step in the future as well. Then you still need qualified advice from lawyers, of course. This is always necessary, but maybe registries, we can just skip them.
Thank you, Philippe. You can leave the room now. Peter?
Peter Müller from Munich. I hear so many like words like threat and fear and danger. I think there is a lot of opportunities coming up because the world is very complex. We are nowadays advising on a global level, which we didn't do like 20 years ago. I remember sending these letters to all my colleagues to answer one question, and the client was waiting 2 months to realize whether he can launch something in a certain country. Nowadays, the client expects us to have some basic knowledge about Chinese law, United States law, etc., etc. And now we are coming up and say, but you're not allowed to consult on Chinese law and US law because you're not a qualified US lawyer. But we are doing it on an everyday basis. We are not qualified US lawyers. We are in the European Union. Still, we give advice on US law to a certain extent to our clients. So, but saying that everything becomes more and more complicated and quicker and even more complex with all these service providers, artificial intelligence, etc. I raise a question right now to the panel, if I may. Have you investigated whether the amount of legal services has risen over the past 20 years, and maybe for the next 10 years, even more legal services are coming up, so all these tools on automatic machines will help us doing our work. Still, we will be like the intermediary with the knowledge about all these machines and how to use them in an effective way. So, do you think that is an opportunity for us?
Yeah, please take the floor.
I think that indeed we need to embrace this technology and take it into our practice and make use of it. And there is this theory that profession is a very expensive way of getting advice, in-depth advice that almost everybody needs, but not everybody gets because it's quite expensive. It's mostly for companies, corporations that ask the advice of a specialized lawyer because they have the budgets to do so. So it might be so that if everything is readily available and less costly therewith, that there will be SMEs, small and medium enterprises, who will be in need of this service and take it anyway because it's more readily available. So maybe that's an opportunity as well. Maybe in a different market. Or maybe we have to do something different all in all and see that apart from what we are doing now, but embrace this technology and go with it, and that can be an opportunity, I guess.
I see Christopher there asking a question, but I would like to answer, if I may, the same. Because I see the future for all lawyers very different from today. I don't doubt that, essentially everything that humans invent in technology and also in social realm stays. Feudalism stays, actually. We have kingdoms, today. Although we abandon feudalism. So the same thing, the radio comes, the print stays, the TV comes, the radio stays. So we just add. This is part of this incredible complexity that we have achieved and that is sometimes so burdensome. The same thing with law, but I think it will be very, very different. I think that law education will need to change because the society is sending clear signs of impatience with how lawyers function now, and especially those of us who are in mediation. I'm looking at you, Mr. Müller, and myself, who have a long time. We know that we need to listen more. Listen more. This is what society expects us. We are trained to think that we are there to deliver opinion and take the money for it, we need to listen. People want us to listen, and once you start listening, you come with all kinds of conclusions and you actually see better future. So I think that the empathic lawyer, a creative lawyer, rather than one that has a high command of skills as number one, is something that we are likely to see. I spoke with some English universities who are very unhappy that they can't find people in the profession who would support this view. So obviously people are thinking already about going into these directions, and I think that this will be essential for profession really to be accepted in the future. Christopher.
Sorry, I would like to confirm that I think there is a huge market, huge potential market that we don't use. There are lots of small enterprises, there's lots of individuals that believe that they don't need legal services, they don't need legal advice, and that they cannot afford that advice. And I would like to mention one thing. Many of you know that there is, for instance, PayPal dispute resolution process, that every year this is basically contractual basis to satisfaction of its users resolves 60 million disputes without the involvement of legal profession, I would like to add. And all these exists, and if we really don't use the opportunity, if we don't take it, then we are going to lose the markets, and but there is a potential. So I'm optimistic. I'm overall optimistic because I think there is a room for us to when potential clients waiting. Thank you.
Christopher Walkham, London. I'd like to. Is it on? Yeah. I'd like first a comment about computers. Back in 1984, I bought a word processor. It wasn't a computer. And one day I realized my clerk who managed my practice was standing at the door. And I looked up and I said, "You look worried." And he pointed at my word processor. He said, "It's that thing I'm worried about." Well, we've moved on a long way. But on computers generally, at the beginning you talked about the searches and things that go on in UIPO and so forth. But of course a computer is only as intelligent as the people who program them. They can make mistakes. But may I also, we've been talking about the legal profession and competition within the legal professions. And what is all important if we're to preserve our systems and provide useful services is every profession involved in this kind of work must be subject to rules of conduct, a code of conduct, remain professional. And while we're talking about professions, if we're looking for competition, let's think about the word lawyer. What is a lawyer? Well, we now have not only barristers, solicitors, attorneys, we have trademark and patent attorneys, many of whom are qualified to do the same work as solicitors and barristers. But what does the Court of Justice say? Those people are not lawyers. Patent and trademark attorneys cannot represent clients after UIPO in the General Court or the Court of Justice, because the thinking in the Court of Justice is they aren't lawyers. Well, I'm afraid that sort of thing, if we're going to preserve our professions and deal with competition and allow free competition, I think the views in the Court of Justice need to change.
Thank you for this very last remark. On the intelligence side, I'm not so sure because Karel gave examples of computers well programmed that do better than we do, so let's see. We have to... Oh, yes, please take the floor.
Hello? Working? Okay. Michael Factor from Israel. My mother was a British legal secretary for 40 years. Shorthand typist, about 140 words a minute. And when I was in college, I did a typing course. I don't have a secretary. When I started working as a trainee patent attorney in Israel, there was a couple of filing clerks whose job was to run around the office looking for files and to replace them. I don't have a filing clerk. I have some physical files boxed up when I used to use paper files. I now work with Dropbox, and I can work from home or from the office, and I've got rid of the support staff. As a result, I've managed to lower my overheads, and I can compete nice with bigger firms. Now, I have a law degree, but I never qualified for Israeli bar as a lawyer. I came in for patents and the technology side. I have a brother as a lawyer. But that doesn't actually stop me consulting on copyright, although I shouldn't really do it, but one does. I don't like the fact that there's Indian companies who contact my clients directly about filing for them and for drafting and so on. On the other hand, I was making $100,000 a year for a Chinese company, writing patents for them from Israel. They don't file in Israel, they file in the US, China, Japan, Taiwan, Korea. But it was set up by an Israeli who worked with me, and he kept working with me. So the profession's changing. I think there's some problems with the basic playing field, where if I do a renewal for somebody in Israel, I have, of a patent or a trademark, it's an asset, I have to charge VAT. I suspect that some of the bucket shops who charge a lot more for renewals aren't paying the tax either. And those sort of barriers are unfair. But there's nothing I can actually do about the non-licensed practitioners, the people that were half-trained, were no good and were fired by other firms, and then set up themselves as patent experts or something, not licensed. This is just the way the world is going. And I don't know exactly where it's going to go to. What I'm absolutely certain is that I'm able to do a patent search worldwide, multi-language. I'm able to access the laws in different countries in English, and I'm able to give an intelligent international service to my clients. And the cheap, non-qualified people aren't what I see as a threat. And so, yeah, the things are changing and will carry on changing, but I don't think that people who are good at what they're doing will have a problem earning very high incomes.
Thank you. Our speakers are still here. Thank you. It's a collaborative work today. So now we have to move on a bit faster because we already are at 22. We have to talk about the changes of the lawyers, which lawyers will survive or not. But first, Mladen, I'd like to have a few thoughts on your part on the future role of law itself.
Thank you again for giving me opportunity to share my, kind of very uncertain thoughts about the future, because really we don't know. I deeply believe the future is that what we build. It doesn't come from somewhere else. So with a little bit of more certainty because of that, I would say that I believe that that we are going to see an unexpectedly strong shift in the future role of law in modern societies. We grew up in the world where it was absolutely paramount, a central pillar of social organizations. It gave our societies an incredible power to grow. Law was one of the, it's more powerful than dynamite. It really made us take off and create an incredible prosperity. But as with feudalism, once you get somewhere, you don't stop there. So I expect us to move away from clinging on law as a central role of society, probably not within 10 years. But I think that probably we will see, it will not go away anywhere, it will be probably in some segments more efficient because it will use artificial intelligence and other technologies like blockchain and those that we still don't know really, but are likely to be deployed. But I personally, I regret that I won't live that long, but I prepare myself for the society that will choose other means of regulation parallel to law. And I I think, if you want really to hear my deep, thoughts, I think that while building European Union, we relied too much on law. That's one of the reasons why we have problems now. Law is not enough to hold societies together. The nice talk about values that we have in the EU should be probably more important than the legal part. Having said that, I don't think it's possible to build it without law, but I would be happy that law goes under the bonnet, like in a modern German car, you don't open it, you bring it to a computer that fixes it, essentially, And I expect law to run our societies a little bit like that, like a cash machine, if you will, So I think that we need, again, to change the training. Someone needs to look at that. But this training must, for instance, include ethics as a component. When Christopher was speaking, I was thinking about, someone programs this stuff. What if the developers don't put in the ethical norms that we expect? You have probably heard about the issues of explainability of decisions by artificial intelligence, or by unlearnability of artificial intelligence that proved to be essential. Probably we've heard about the Microsoft chatbot that had to be turned off after 16 hours because it became a racist. It was on Twitter, and it started tweeting things like, you are stupid because you are Mexican. I mean, you have screenshots on the internet of this, what this chatbot was doing, and they couldn't unlearn it. They had to turn it off. So if the programmers were thinking about the ethical aspects, that artificial intelligence would probably not start misbehaving, what we humans perceive as misbehaving, although that artificial intelligence learned it from us, ultimately. But it's still not an acceptable behavior. So this must be, so the lawyers, people who understand ethics, humanistic people. So we see a world where borders are generally being diminished. I am aware that there are a lot of things to point to the opposite, but still I think that that's the process which we are seeing. So I think that there will be shift of role of law, not meaning it will be less important, it will be on a different place, probably.
Thank you. That gives us a lot to think of. Monique, I'd like you to say some words about the future of our professions, how you see it, in-house, paralegals and so forth. What will be their role or not in 10, 20 years, please?
I think that in-house lawyers, as said before about clients, because in-house lawyers sometimes are the clients, they have a need for more efficiency and less costs. And I think that will make them need to reshape their IP department. I don't think that IP departments in-house that are existing right now will be the same in the future. For example, as in also the prosecution practice, they have to digitize their administration, and they probably will, which will mean less people for that. And also there will be a need for outsourcing, especially formalities, because it will be much cheaper to do it somewhere else, especially with the new technologies. So they will need to outsource that, and they will probably also need to outsource deep expertise as they do right now. So they will probably have a new role also, maybe more of an outsource and procurement manager, and next to their more traditional tasks such as making strategic choices, risk management, and providing information to the management. So a new role to be adapted. As far as paralegals go, not necessarily in-house, there will be less administration because of all the technology invented yet and to be invented. Things will be digitized there will probably be no need to file applications for registration or renewal or recordal. And also there's less administration because they will probably not have to make cost estimates and budget estimates because that will also be digitized. Also they have less work looking up things because of service providers such as Darts IP and their products. So I think paralegals need to embrace this technology and also gain a different role. And they will probably be right behind the lawyers in that matter. So they have to be more high-end, high-quality advice. And paralegals will probably be able to give high-quality advice with less training due to all the information that is readily available. As far as in-house paralegals go, I guess I see a little less opportunity to gain such a new role, but maybe I'm mistaken.
Yes. Orlando Vieira from Venezuela. I think that Mr. Buckmer has introduced a very important point, as is the ethical point. One of the issues that I would like to introduce in the discussion is the use of the social media. It is amazing how reputation of people is destroyed every day throughout social media without any control. Even some presidents use the social media in a way that just change the way how to accept and to admit and to tolerate the reach of the information, of the opinion throughout the social media. I think that maybe lawyers, one of the functions is to create conscience about what could happen if the use of the social media in any group could affect the reputation and even the well understood of the politics throughout social media. The second point that I would like to discuss is about the future of, for example, the YouTube. It's amazing how, because the traffic in YouTube, the Digital Millennium, to give you an example about the Digital Millennium Copyright Act in the United States, gives too much protection for YouTube, and how too much copyright had been infringed every day throughout YouTube without any legal content and action of this servitor. How we can do to create some kind of universal organization to get a balance of this huge infringement throughout YouTube. Thank you.
Thank you. Thoughts?
I would like to perhaps add what Monique has said about the individual legal profession, paralegals and so on. I think the most vulnerable profession to all these changes that are coming is the position of a junior lawyer, junior associate, trainee lawyers. Because if you look what activities are going to be automated in the future, it's a case law research, legal research, contract review, litigation, outcome prediction, as I mentioned the example at the beginning. And most of these activities are those we currently entrust junior lawyers. So I think their position is most uncertain. And there is even a study, I think McKinsey made a study how much of our work will be automated, and they estimate that 25% of the work we as lawyers or trademark professionals now do will be automated, and more than 1/3 of what the paralegals do.
Thank you, Carol. Mrs. Gravoker, you wanted to say something?
Yeah. As a judge from Germany, I miss one point in our discussion. How will be your role in 10 years in relation to courts and to judges?
You guys.
I think that, you know, again, it will remain tremendously important for certain cases to be, that there is a possibility to resolve them in a high-quality court. It is true that many countries are not really equipped to maintain a high-quality judicial system, especially if it is a small market and languages that are not used by the others. So it's difficult, you know, you never get the depth of answers from any existing law because this market is too small for the questions under such law to appear even to court. So there's always high degree of unpredictability. And only the biggest jurisdiction, but in my opinion, with ever more effort, are able to maintain a meaningful court system. So I think that the courts will be more professional in the future. They will be like a dream courts for today, but they will be less used. And a lot of disputes will be resolved on interest-based rather than on a position-based, which is legal system is position-based method for dispute resolution, while mediation is one example of the interest-based approaches. I think that we will see a sharp increase, in spite of the slow adoption by mediation now. You know, I actually think it's not slow at all, because it is so deep change for our societies to switch from adversarial type of approach to disputes to a collaborative, interest-based seeking for solutions jointly, that I think that it's actually very fast penetration of mediation in modern societies. I expect this to continue, and the courts will stay. I'm not sure about the arbitration, because it became so mind-numbingly complex. The arguments that you have in arbitration, it's really something outlandish, more or less now. I'm an arbitrator and I represent in arbitration, and sometimes really I scratch my head, you know, when I see how far it goes. So courts might even be more friendlier and used in the future. I don't know. 3 years ago I wouldn't say that.
Thank you, Mladen. We have a third part in this session dedicated to billing and costs. We won't have time for it now. It will be in the swimming pool at the end of the sessions today. The panel and myself will be there to answer questions. So we'll finish with a second part. Mladen, again, I will give you the floor, but short, please, because I think you are very happy with how we, the IP lawyers and firms, prepare and react to the future. Is this a message of congratulations you want to give to everyone?
Well, you know, that's what made me very proud when I joined profession back in late 80s, early 90s. I really thought that it was a forward-looking and open-minded profession, globally oriented, and generator for good in our societies. Over the years, I became less sure about that, and probably the profession changed. And in my perception, nowadays we are more defensive and probably, you know, unnecessarily so, because creating change is fun, and this is what I invite everyone to try. You know, as I said, I think we should have more fun. And we are a bunch of really highly educated, you know, and creative people, and I would love to see all this coming to the surface. Thank you.
Thank you. Now I'd like to ask to Monique and Karel, if your kids go to you and ask you, or say, I want to study law and become a lawyer, and in particular a trademark lawyer, will you kick them out, or what will you advise them to do? Is there a future for these young people, or what should they learn for the future?
I think we should let the kids and our children decide on their own. We should not advise them what to do.
Come on, give the right answer.
think I would advise them, if they would like to do so, advise them to do so, but also tell them to be flexible, you know, and to be able to change things and not think that everything will be the same. So if they go into a study like law, which is always under development, but they have to be flexible and ready to embrace technology and ready for changes.
It seems as before we were good IP attorneys if we could speak several languages, and the future lawyers will have to be lawyers and software engineers, no more or less, and very understandable of technology. Thank you very much. I think we will stop here. I'd like to thank the audience. You've been very active. We have had fun, at least from this side of the room. And thank you to the panel for all its preparation work. It's been intense. And enjoy the rest of your day. Thank you.